Welcome to Legal Training for Navy JAG, serving as Special Victim Counsel representing child victims of sexual assault, co-sponsored by the ABA Center for Children and the Law and the ABA Center for Professional Development. Moderating the program today is Anne-Marie Lancourt. Anne-Marie is the Associate Director and Director of State Projects at the ABA Center on Children and the Law. Anne-Marie, please proceed with today's program.
Thank you so much. Joining me today on the program is Stephen Kelly, who's an attorney in Baltimore, Julie Kenniston, and Dr. Joanne Solchaney. Stephen is a member at Silverman, Thompson, Slutkin & White, LLC. Julie is a consultant located in Cincinnati, Ohio, and Joanne is a psychologist located in Seattle. Before each of our speakers speaks, I will be going over their bios so that you can hear who's going to be joining us on the phone today. I do want to thank all of you who have called in and joined us today on this webinar for Navy, who represent, who are Special Victims Counsel representing child victims of sexual assault. We realize that a lot of you are joining in either during your day or late in your evening, and so we do appreciate all of you taking the time to join us. So thanks again. We look forward to hearing your questions. I would like to be clear that your questions actually, when you, we'd encourage you to submit them online on your computers if you can, and anything you do, you don't have to, we won't identify who they're from. We'll just be using the question unless you want us to identify where they're from. If for some reason your computer, you're not able to access in, please, you can call in afterwards. We will have a question and answer session at the end of the program as well. I'd now like to turn this over to Julie Kenniston, who is an MSW and LISW. Ms. Kenniston is the former Director of Training and Education at Butler County Children and Youth in Hamilton, Ohio, and she's the Volunteer Executive Director of the Center for Family Solutions. She's also an independent contractor and trainer, presenting nationally and internationally on interviewing, investigation, and prosecution of child abuse cases. She's a trainer for the Office of Juvenile Justice and Delinquency Prevention and the American Professional Society on the Abuse of Children, the National District Attorneys Association, and the Ohio Attorney General sponsored Finding Words Ohio. Ms. Kenniston organized and coordinated the Forensic Training Institute for the Childhood Trust in Cincinnati, Ohio, which started in August 1997, and she has trained on the program since its inception. She is a board member for the American Professional Society on the Abuse of Children, APSAC. She co-chairing the Forensic Interview Certification Task Force. Ms. Kenniston was a sex abuse investigator for Hamilton County Department of Human Services, where she conducted over 3,000 forensic interviews of alleged child victims of sexual abuse. Ms. Kenniston is the co-author with Ann Graffam Walker, Dr. Walker, and the co-editor was Sally Smolinata from the ABA on the third edition of the Handbook on Questioning Children, a linguistic perspective that's published by the American Bar Association Center on Children and the Law. And with that, I'm happy to turn it over to Julie Kenniston.
Thank you, Anne-Marie. Hello, everyone. I get the pleasure of talking with you about the language that you use when you talk with children. So you listen to Dr. Solchaney talk with us about the different developmental issues that children bring to the table. And what I want to talk with you about is what you do in terms of language. So here's a visual of the book, and you can certainly access that book through the American Bar Association. It has some very helpful tips on the way that you talk with children, the way that you gather information from them at different levels, preschool, school age, adolescence, individuals with developmental disabilities. So this is an excellent resource for you if you would like something further after we have time today. So the focus that I have is these four things. We're going to look at interview instructions. We're going to look at truth and lie. We're going to focus a little bit on competency, and I'm going to talk with you about a very important research-based approach to gathering information from children called narrative event practice. So let's start with the interview instructions. Any of you who have ever witnessed a forensic interview, particularly if the person conducting the forensic interview was trained in whether it's NICHD, the National Institute for Child Health and Human Development, or any of the other particularly the 5-day forensic interview models, you've probably seen interviewers use these instructions to lay the foundation for what children should do and in their conversations with adults, and things that will also minimize suggestibility. These questions are correct me, don't know, don't guess, and don't understand. So correct me is all about letting children know that if we as adults make mistakes, we want them to correct us. And if you think back to what Dr. Solcini talked about, that can be very helpful, not only because children at younger ages follow the rules, but also because we want to make sure that we're not putting ideas into children's heads even when we misspeak. So the way that might sound in a forensic interview would be, so if I said you were 30, I'm sorry about that. If I said you were 30, what would you say? And the child usually, particularly when they're young, will say, I'm not 30, I'm 6. And what we want to do is just reinforce to them that anytime we're speaking, that if we make a mistake, they can correct us. Now, those of you that are parents know that's not typically a parenting rule. We don't sit around the dinner table and say to children, hey, kids, if I tell you that you need to go to bed at 10 o'clock and you don't believe that, you want to correct me, go ahead and do that. So a lot of these instructions are pretty important to undo some of the social norms that occur in the context of parenting and other things. The don't know, don't guess rule is very helpful, particularly for those of you who are working with children and you're trying to figure out what they want. So the don't know, don't guess rule would sound something like this. If I ask you a question and you don't know the answer, I want you to tell me that you don't know. I don't want you to guess. So, for example, if I ask you, what did I have for breakfast this morning, what would you say? And hopefully the child will say that they don't know, and you can follow that up. What I will then say to the child is, if you do know the answer, I want you to tell me. So if I ask you, what did you have for breakfast this morning, what would you say? And then hopefully the child will answer those questions. The don't know, don't guess rule is extremely important when you are trying to get at a child's knowledge of an event, but also in the context of the work that you do, that they're not just providing answers if they truly don't know how they feel about it. The I don't understand rule is very important because we as adults often use big words with children, even if they're not long and have a lot of letters in them. Sometimes they're abstract words, the things that Dr. Solcini referenced. Words like court to a child isn't typically the inside of a room where people are making decisions. It's more like a basketball court or a tennis court or something like that. So the don't understand rule is really prompting children when they have questions about or they're confused about the things that they say. It empowers them to tell us that they don't understand. So what I might say to a child is, if I asked you, what is your patella, what would you say? And if the child says, I don't understand what you're talking about, or I don't know what you mean, then we can say, well, your patella is your knee, and so what I'll do is change it in, words that make more sense. So those instructions, the reason why this slide says interview instructions cross over is that those instructions are really important for people that do forensic interviews, those that are gathering information for the court, but they're equally as important in the court system. So whether it's a child testifying or whether it's you representing a child, empowering them to give you accurate information can be very, very helpful. In the truth-lie research, which is another instruction that often goes along with forensic interviews, and I understand that this may not be really the role that all of you carry, but important nonetheless to the work that we do. In the most current research, it really shows that eliciting the promise to tell the truth has more impact than some of the ways that we might have done truth-lie discussions in the past. So if I said that my shirt was red, is that the truth or is that a lie when I'm actually wearing a black shirt? We learned over the course of many years that doing something concrete, because we know children are concrete, particularly young ones, doing something concrete for that demonstration can be very helpful. And so many of us have used those demonstrations for years and years. What we know now is that it's probably more important for us to say to children, do you promise that you will tell the truth today, and get them to make that promise or for us to elicit that promise. That's actually what gets us more accuracy and commits the child to the truth telling itself. So let's spend a little bit of time talking about competency and what competency is all about. Now, I'm going to focus on competency in terms of a witness, a child witness. But what I also then want to talk with you about is how you can look at competency when you're trying to figure out what children want and some of the decisions that they're making. When we look at court competency, there are 4 elements to that. One is the ability to recollect and recall. And thinking through what that means, what we're saying is that regardless of age, thinking through what Dr. Solchenyi said, regardless of age, children really pretty early have the ability to put words together to talk about events that they experience. So in our talking with them, we want to give them that ability. And thinking about how we as adults often talk with one another, it's how are you? What have you been doing? If I want to find out about one of you and what you're doing in your job, I might say, how long have you been doing this work? Where have you been? Have you always practiced in this city? And so as adults, we're very, very used to asking closed-ended questions. And as adults, closed-ended questions can prompt more information if I, as an adult, think you want more information. So you might say to me, so Julie, where do you practice? And I tell you just north of Cincinnati, and that's it. It's a closed-ended question. I give you limited information in my response. But if I know that really your question is asking, have you practiced other places or something to that effect, I might give you more information because as an adult, I can process that your very closed-ended question was really seeking more. Children don't tend to do that. So in the techniques that I talk with you about in just a little bit, I want to talk with you about how you can increase the amount of information we get from children because they don't necessarily get those social conversational cues to give more information. So this ability to recollect and recall an event and then to speak to that is really, really important. The ability to perceive accurately is also very important. So we heard Dr. Solchenyi talk about fantasy and the child riding the moose in the backyard, even though there are no moose in Seattle, but really thinking through of the information that children give us, is it accurate? Is it coming from a place of fact? Is it something that we can rely on in order to make our choice decisions? The ability to differentiate truth from lies and demonstrate this knowledge, and to show that in this case, a child knows what happens if a lie is told. That's where a lot of our old truth-lie demonstrations or truth-lie discussions used to occur in forensic interviews. If I said that my shirt is red, is that the truth or is that a lie when I'm wearing a black shirt? If I said I'm wearing a watch, is that the truth or is that a lie when I'm actually wearing a watch? Doing those demonstrations, we did that very much to show that children were competent when in reality, knowing now what we know, we really just want to get them to promise to tell the truth. And we've already spoken to that. So this final piece is the ability to speak from personal knowledge of the facts. As a witness who has testified in court, I know that unless I'm an expert witness, I am really only supposed to talk about things that I experience, things that I see with my own eyes, hear with my own ears, or feel with my own body. And that's something then when you combine the recollect and recall and speaking from personal knowledge of the facts, that can really help us in demonstrating whether or not a child witness is competent in terms of court processes. Now, I want to take a minute just to talk about competency and the work that all of you do and think through how do you know when a child really understands their situation and can give feedback to you about where they might want to go. And I think as I kind of have thought through this concept to really choose some of the pieces that we might want to discuss this morning, or for me this morning, for many of you not, is this idea of first understanding what a child's ability to discuss information that they recollect and recall or information they experience, to think about that ability, and then also to understand from this developmental perspective that Dr. Solchenyi talked about is children and what they rely upon. So when you're thinking about competence and in a child, what do they want in a certain situation, where do they want to be, or as a victim of something, what would they prefer to happen, really combining these concepts of the psychological and the affective and the emotional, along with what they're able to do, what they're able to tell you, is hugely important because they might be able to tell you and be a very competent witness in court, but what they choose to tell you is going to rely on maybe emotionally what they need at that developmental stage, or cognitively what they understand to be true, or perhaps the stress reaction because all of these separations are so difficult for them that even though they have a sense that it wouldn't be good to be with a parent or to be around a certain person, that they would prefer not to have that level of stress. So combining those two things I think is very, very important. So let's talk about a practice that it has become really the premier approach in all of the forensic interview models, at least that are presented nationally in the U.S. And this concept is called narrative event practice. It's called other things as well. It's called episodic memory training or episodic practice. But the focus here is that we're trying to get children to talk more fully or in lengthy sentences to the best of their ability, not just answering one or two word, giving one or two word responses to our questions. Narrative event practice demonstrates three of the elements of competency, because what it does, if we go back here, is it's going to help a child, and it's going to demonstrate that a child can recollect and recall an event. It can give us some indication on whether or not they're perceiving things accurately, and it's going to show them that they're speaking from personal knowledge of the facts. Let me explain to you what narrative event practice is. The idea behind narrative event practice is that you as the adult will ask the child to think through or to talk through an event that he or she has experienced and give you details around that event. So what we do then is we're undoing current communication culture, this idea that we sit at the dinner table and say to our children, how was your day? Fine. Do you have any homework? No. What did you do today? Nothing. And so at our dinner table or at wherever it is that we might connect with our children about their day, we as adults ask these very closed-ended questions and we get these one-word responses. And in this little dialogue that I just shared with you, it's not even an accurate response. The child actually does have things that he or she did during the day. So when we ask, what did you do today? And the child says nothing, it's not even an accurate response. So this narrative event practice teaches children how to communicate. And it really, for our purposes in the legal system, it really makes the child the expert instead of us having to guess what it is that they know or what it is that they have to share. So how do we do narrative event practice? The first thing that we're going to do is pick a neutral event. The key to narrative event practice is that it's neutral and non-abusive. Many of you are going to be talking to children about traumas that they experience or the ways that they feel about things that are very difficult in their lives. And so to do this narrative event practice, we want to pick something that's neutral and non-abusive, something that's easy and has very, very little risk for them to talk about. We want the child to tell us everything about that event and not interrupt. We want to allow for pauses when we talk to children. And so let me give you an example of this, and then we'll talk about where we go from here. What I might do with a child is say, so tell me about something that you really like to do. And if the child says, I love playing hockey, I will then focus the child on one time that the child played hockey, because I want them thinking of one individual account, not the routine or what usually happened, but one individual account of playing hockey. So I might say, so I want you to think about the last time that you played hockey, and I want you to tell me everything about playing hockey the last time. I might add, if the child is older, from the beginning through the middle to the end, even the little things that you don't think are important. And by not allowing or not interrupting and allowing for pauses, the child gives me often lengthy responses. Now, this is either in a sentence or maybe in paragraphs. And what I want to do then as the adult is follow up with narrative inviting questions. So not what you wear when you play hockey, that wouldn't be narrative inviting, and not to say, who are you with when you play hockey, but to say, I heard you say that you played goalie, tell me all about playing goalie. Or I heard you say that you went to the hockey rink, tell me all about the hockey rink. The idea is that we're really pushing for more narrative, showing that we can be a very good listener and give information or get more information from the child's perspective. What can be very helpful, particularly with young children, is that we focus on actions or the things that the child did, the verbs, what did they do during this event of playing hockey or whatever it is, whatever the event is that we're discussing with the child. And we're listening to the child's ability to describe and give these activities in a logical sequence. So what this does for you as the representative of the child or thinking through what the child might be able to do, it gives you a sense of what the child perceives, how they can tell an event. And when you start to inquire from the child what they want as a victim or what the child really would like to do in certain situations, you'll have a baseline from something that wasn't really risky to talk about. You're not really looking at some of the impact of trauma necessarily on how they tell you. The impact of trauma might come out in the way that they tell or maybe memory issues, but not necessarily in just the way that they talk. So this narrative event practice gives you a baseline for the child's abilities. Let's look at some of the benefits of narrative event practice. So as the interviewer, and when I say interviewer, I'm really talking about you, the person that's speaking with the child. As the interviewer, you're engaging the child. you are showing the child that you are a listener and that you're paying attention. And in your work, that's what you're trying to do. You're trying to figure out what it is that the child wants or needs, how you can represent the child the best way possible. Like I stated before, you're getting a baseline of the child's ability and willingness to communicate with you. And those two things are hugely important. They're very different, but they're very important. If you're interviewing a 3 or a 4-year-old, for example, you want to get an idea of how well they can communicate. And this has very little to do with confidence just as a topic, but just in terms of their ability to talk. Can they even talk to you? Are they able to use words? And then taking it that next step further on their competence to give you information, the information that you're seeking in your representation of the child. And then their willingness to communicate, particularly with children that for whatever reason, one reason or another, maybe because of trauma, maybe because of relationship, they're choosing not to share information with you. So ability is one thing, but willingness is another. And this narrative event practice gives you a baseline of both of these things in talking with about a neutral, non-abusive event. The interviewer explains and practices with the child the way that information will be shared. We really want to hear things from the child. The child is the expert on the child's life. We are not the experts on children's lives that we're serving. We want that information from them. And inherent in that concept is where you get this idea of whether or not the child is competent. The interviewer shows interest and doesn't interrupt. I referenced that in an earlier slide, but this is one of the benefits. The interviewer demonstrates that there will be follow-up questions, even when the child provides a lot of information. And this, I think, is absolutely crucial because we very often shut children down when they have much, much more to give us. They're processing information at their developmental level, and we want to get out of the way. We want to understand what it is that they're processing. The interviewer shows that the child is an expert on his own life details by allowing the child to tell what he knows in his own words. This one is directly related to that fourth issue of competency, this personal knowledge and facts. We're allowing the child to talk about a life experience. We're getting out of the way. We're hearing it in the child's words, and we get a better sense of what the child's understanding is of the event. The interviewer demonstrates that the child can recollect and recall. So by getting the child focused on an event that is typically fact-based, child playing hockey, that information then gives us a sense of whether or not they can recollect and recall an event. The interviewer gets a sense of the child's perception of the event and ability to observe. So this is where, as the representative of the child, you want to understand what it's like for the child living in a home environment or as a victim of one thing or another. So this narrative event practice gives you an immense amount of information, not just whether or not a child can be a competent witness, but what the competence of the child is when you're looking at gathering information and trying to make decisions. The interviewer receives data that is unsolicited. This is probably one of my favorite parts. The details that I get from children when I ask these types of questions and get out of the way so that they can just talk freely, the amount of information that you get that you do not in any way indicate or suggest to the child really shows that what is being stated from the child is not highly led or suggestive. The interviewer gets information that can be corroborated by the multidisciplinary team. That's what MDT stands for. And so for me, for doing injury forensic interviews, this is hugely important in understanding what's occurring in cases because we don't ever get all of the information in an investigation solely from the child. We get information from caregivers. We get information from suspects. We get information from others that are in the child's life, witnesses and people that the child is disclosed to. So the information from the child interview can be corroborated outside of that forensic interview. And the interviewer can refer to the narrative event practice later in the interview when the child's answering in fewer words. So often what I'll say to the child is, I want you to tell me all about what happened at your mom's house, just like you told me about that last hockey game you played. Or if I've asked the child maybe to do a narrative event practice on their morning, think about your morning and tell me all about your morning from waking up to going to school, and they've narrated through their morning. Later in the interview, when I'm talking to them about other things that maybe are abusive or traumatic in nature, I'll say, think about whatever time it is I'm focusing on and tell me all about it, just like you told me about your morning. So where I want to now just focus the last few minutes that we have together is this idea. I want to expound on this idea of concrete versus abstract thinking and why this is crucial for court personnel. Dr. Spolcini talked about how younger children are concrete, and she talked about how they begin processing pretty early some ideas and incorporating ideas into the way that they view the world. And so as we think about it, concrete things are things that are very literal. They're things that you can touch or experience or engage with. And so in this list of who, what, where, when, how long, how many times, and why, if you think about a who question, a who is a person, and a person is someone that you can touch or engage with. So a who question is concrete because it's literal. You can touch a person. What is also concrete because what is, it could be a table, or what could be a what happened, he kicked me, or what. Those things are things that are interactions or things that you can touch and experience. They're literal. So who and what are concrete questions. Where is also a concrete question. A location is concrete. You can touch a room. You can touch the inside of a car. And so of the who, what, where, when, how long, how many, and why, who, what, and where are the concrete questions. You can't touch a when. You can't touch August 8th or yesterday. You can't engage with that. It's not literal. It's abstract. It requires a certain amount of cognitive processing to understand that concept. And the same goes for how long, 12 minutes or 2 years. Those things are not things that you can touch or engage with, so they're abstract. How many times? 12. That's not something that you can reach out and touch or engage with. It's not literal. And then why, this idea of cause and effect. You heard Dr. Spolcini talking about children very, very early beginning cause and effect, but in a very concrete way. If I giggle, then my mommy will smile, those kind of things. Those are two very concrete things, but they're just starting to think through the very basics of cause and effect. Why is also abstract because why very often comes across as a child trying to take the perspective of someone else. Why did your mom come into the bedroom? Or why did your dad hit you? And that's a very abstract thing. A child who we've heard throughout our presentation here today, very egocentric, focused on themselves. They're the center of attention. Very difficult to take somebody else's perspective. So in this question strategy of who, what, where, when, how long, how many times, and why, if children are concrete, and you heard that many of the children, based on development, are concrete, we want to focus our question strategies on the who, the what, and the where of the event, and to really try to steer clear of the when, the how long, the how many times, and the why. We can get that information, we can get that data by getting concrete information about the who, the what, and the where. So let me give you an example of this. If I am interviewing a child and she tells me that some type of abuse has occurred in her home, and I ask her to tell me all about the abuse, I want you to think about the last time and tell me all about it, from the beginning through the middle to the end. And she tells me that she was playing in her bedroom and they were playing with her new video game that she has. And her cousin Juan had come from California and they were spending time together playing the video game. And her father came into the room and told her that she needed to turn it off and it was time or she was going to be in trouble. And she and Juan continued to play the video game, and the father came in and grabbed her by her arm and threw her down away from the video game and hit her with a belt. If you say to that child, when did that happen, it would be very difficult for the child to put all those pieces together. That's an abstract thought. But as the interviewer, you receive that information. You know who was there. You know it was around Christmas. You know that it was after receiving the video game, so you can pinpoint what Christmas by perhaps asking an adult. You can find out when Juan, the cousin, came from California. You can even corroborate perhaps tickets or other things that will give you the when information. So the key here when we're looking at gathering information from children is to get them talking as much as possible and to really allow them to focus on what it is that they've mastered, the concrete concepts in our language, the who, the what, and the where. And my hope for you then is that this will assist you as you're gathering information, using this narrative event practice, getting children talking. It will not only give you information to help you understand better what has happened for children, what they've experienced, but also what their desires would be as victims of abuse or witnesses of abuse, and some of the things that that maybe they would like to see happen, and whether or not you feel like they're competent to give you that information. So with that, I'm going to turn this back over to Anne-Marie.
Thanks so much, Julie. That was really helpful. And whenever I hear you presenting this, and it's been, especially the narrative practice, it's been a few times now, I always learn so much, and so much that I wish that I knew when I was in practice. And as a side note, it's also been helpful with even my child who went off to college using a few of your techniques. I've gotten much more information than I would have if I just asked the closed-ended typical mom questions. So for both ways, I'm appreciative, and thanks so much for the great information. A quick reminder that if you'd like to type in any questions ahead of time, we'll be glad to take them as many as we can at the end of the program after our last speaker. And Julie mentioned the Handbook on Questioning Children earlier. That is, we do have it available at the ABA, and I actually believe that the Navy is trying to get some copies of those available to you in the field as well. So happy to answer any questions about the publication after this webinar as well. I'm now going to turn it over to our third speaker. Stephen J. Kelly is an attorney. He's a victim survivor who is recognized national leader in pursuing creative justice for crime victims by representing victims in criminal and civil cases. Steve became involved in the victims' rights movement after his older sister was murdered in 1988. Steve is a 2003 honors graduate of Georgetown Law School, and prior to law school, helped to find a first-of-its-kind program matching crime victims with attorneys as a program director at the then Stephanie Roper Foundation. Steve served as a law clerk to United States District Judge Richard Bennett, served as a litigator in one of Maryland's largest and most prestigious law firms prior to starting a crime victim litigation practice at Silverman, Thompson, Sluckin, and White, LLC. Governor Martin O'Malley in Maryland appointed Steve as commissioner to the Maryland Criminal Justice Injury Compensation Board in 2009. Steve has been honored for his work for crime victims by the American University and National Crime Victim Law Institute, the governors of Florida and Maryland, the Roper Victim Assistance Academy, and the Maryland Crime Victim Resource Center. In addition to his memberships with the National Crime Victim Bar Association, Steve serves on the board for the Maryland Crime Victims Resource Center and on MAD, Maryland's Operations Council. He is an active supporter of the Maryland Sexual Assault Legal Institute, the Network for Victim Recovery, D.C., the National Alliance for Crime Victim Rights Attorneys, and the American Bar Association Victim Committee. And with that, I am happy to turn it over to Attorney Stephen Kelly.
Good morning, everyone. I'm here in the city of Baltimore, and we're in mourning for the loss of our beloved Orioles yesterday. But if anybody's in Kansas City, congratulations on an excellent championship. I'm here to talk to you about this crazy concept of being a victim's rights lawyer. And the first thing to keep in mind, and that you will quickly know if you haven't been introduced already, is that your client is not a party. Everybody will want to remind you of this immediately as soon as you enter the scene, the judge, the prosecutor especially, and the defense attorney. So what I'm here to do is sort of, from my experience representing crime victims and specifically children in court, both as a guardian ad litem and victims' rights attorney, is to give you a flavor for how do you deal with some of the practical difficulties. Julie and Joanne did a great job of sort of setting forth the skills that you'll need on working with your clients, and I'm going to focus on sort of the legal practice. The two questions that I get from new lawyers who are doing this kind of work is, how do I know where to stand? What do I have standing to assert? What can I assert versus the prosecutor? So hopefully I'll give you a little bit of a flavor for that. First of all, understand that even though your clients are not parties to the case, they do have certain procedural rights. And the rights are contained in various places, but these are essentially the important right. The right to be informed of all relevant proceedings, the right to be present, the right to be heard, the right to restitution, protection, privacy, and confidentiality. And I'm going to talk to you about issues that arise commonly with these types of rights, but these are essentially the procedural rights. And we're not going to have time to go through them all in detail, but what I want to do is let you know that there is a body of law out there that can help you. Fortunately, with the Crime Victim Rights Act and the enactment at the federal level, there's a lot of litigation that has happened at the federal level that I think would be useful to you all. And there is a wonderful website, which I've included in the slides, www.victimlaw.org, which is a very easy resource guide for attorneys on victims' rights. It has a pretty up-to-date, although not totally up-to-date, database of cases and statutes on every topic that you can imagine from, and you'll see it at the bottom of the screen here in the slides, all the different rights, or, you could search by the type of right. You can search within the jurisdiction to find out, what courts have said about whatever issue that you're encountering in the victims' rights world. So you're not starting from scratch. This is a new frontier in the law, and one of the frustrating things is that you will be pushing the envelope because the criminal justice system, as many of you are aware, is a very closed insider-type place, and you are by necessity an outsider. So to the extent that you can find legal precedents to arm yourself with and show judges and prosecutors and defense attorneys that other courts have recognized these rights and there's been extensive litigation about these rights, that will only help you. Also, in addition to the legal resources, there are networking resources, which I would encourage you all to take advantage of. The National Crime Victim Law Institute is a network of victims' rights lawyers. I call them the ACLU for victims. They're a very good group of lawyers who provide technical assistance to victims' rights lawyers. They provide assistance with appeals. They provide amicus support. I would encourage you all to get in contact with them about any issue that you have. The same issue goes for the National Center for Victims of Crime. They have a network of civil lawyers who represent child victims, which is a great resource for anybody who has a potential issue in either a civil suit for damages or in an ancillary case involving, guardianship or custody or anything like that. They are a great resource. In addition to the lawyer resources from the National Center, there are resources, with regard to the apparatus that supports the criminal justice system. In every state, there are victim rights advocates in most of the prosecutors' offices. In many cities and states, there are victim advocates within law enforcement. And, a lot of these groups are federally funded. They're independent nonprofits. Every jurisdiction has a child advocacy center. These are many times include mental health professionals and others that you can loop into. And I would encourage you all to figure out where those resources are, in your jurisdiction, and to try to tap into them to the extent that it's possible and good for your client. The most important thing for you to do, and this is, applying the skills that Julie and Joanne both talked about, is figure out what your client wants to do. The thing to keep in mind about victims' rights is that they're very weak. A lot of people say they're a toothless tiger. They're a right with no remedy. That's not strictly speaking true, but what you do need to keep in mind is that because victims' rights are relatively weak and are vastly outweighed by defendants' rights, you need to be very proactive in your approach. You need to figure out what rights are at issue and to do everything you can to prophylactically assert those rights and protect those rights. The first step in doing all that is to sit down with your child victim and or other resources like therapists, the parents, and keep in mind the privilege issues that you have to deal with. Work those things out in advance, but get as much information about what it is that your child is afraid of in the process and what your child wants to get out of the process, because you need to map out your plan as to what rights those wishes are going to implicate and how best you can go about protecting those rights. The first thing that I tell folks is, as a victims' rights lawyer, you need to get in touch with the prosecutor, and you need to do your best to make the prosecutor your friend instead of your enemy. Prosecutors are very reluctant to have folks like us come in. I've had tremendous hostility from the very beginning with most prosecutors. They think that you're trying to run their case. They think that you are going to make their life more difficult. Some prosecutors fear that you're going to resist their normal practice of offering plea deals, which you may have to. But the best thing for you to do is to call the prosecutor, reach out to them, let them know that you're here as a resource. You can serve as a conduit because you can communicate not only with the child victim but with the child victim's therapist, with others, and you don't have the same kind of Brady obligations that the prosecutor will have. The prosecutor has an obligation in discovery to turn over a lot of communications. You can act as a conduit by sort of buffering between the child and the child support network and the prosecutor, and thereby, protect a lot of the confidential information that your client has to offer. And prosecutors often see that as a benefit. You want to find out as much as you can about the defense attorney. What kind of person is this? One thing to keep in mind about defense attorneys is good trial lawyers will not attack child victims at trial. Everybody knows that. What people don't realize is they'll do their damnedest to attack your victim every step of discovery, and they try to intimidate your victim through obtrusive discovery mechanisms and through, basically, just making the victim, the child victim, and the child victim support network nervous about the level of invasion of privacy and the difficulty of the process. And there are things you can do to shield that, but you want to find out from the prosecutor whether the defense attorney has indicated any interest in doing that sort of thing. Immediately enter your appearance. I don't know if there's a procedure in your practice for doing that, but I encourage you to, in whatever way you can, to enter your appearance and file a written document that, whereby you're demanding all of the rights that your client wants, and, the right to be informed, the right to be present, the right to be heard. Most states have forms that, in Maryland we have what's called a victim notification request form. I have a form. I'm happy to provide it to anyone that needs it or wants it, that basically just says that I preserve my client's rights. This is really important because, as I said, rights are often without remedy. You can usually not stop a proceeding as a victim. You can usually not reopen a proceeding. So the best hope you have is to make the court aware in advance that you want to assert your client's rights and to have that in writing on the record. Your appearance is important because you want to make sure that your client is absolutely informed of everything, every aspect of what's going on, including plea negotiations, including any ancillary proceeding. You need to be informed about it. And to the extent that you make a record with the court, you increase the chances that you're going to be informed about it. Here are some just common issues that I see in my practice, and I think they're the most common issues. The first issue is the privacy of the child not being protected through redaction. Most federal rules, and I'm sure your rules, require redaction. And a lot of lawyers are good about redacting names and identifying information about the victim. That not only means the victim, but if the victim is identified as a relative of the perpetrator, for instance, the son or daughter of the perpetrator, you may also ask the court to either use a pseudonym or redact the name of the adult, because identifying the father will identify the child. So you can be aggressive about this. There's great law out there protecting the right to redact. The other thing to keep in mind is that oftentimes prosecutors especially will redact court documents, the facial documents, but they will not redact things like affidavits in support of search warrants. So you need to look through all those documents when you get into the case and make sure there's nothing on the public record that has your child's name or identifying information. And the authority is there, 18 U.S.C. 3509, this Duncan case in the Third Circuit, just two examples of aggressive laws protecting, the right, the need for privacy in terms of court documents. Testimonial accommodations. This is a really huge issue. Child victims have the right to seek testimonial accommodations, and you should, for most of the victims, they will want testimonial accommodations. Prosecutors will resist you in doing this because they want the jury to see the child testify. And many times that's not good for the child. Testifying in open court, looking straight at the perpetrator, is oftentimes not good for your client. There's a whole body of law that is set forth in Maryland versus Craig, which I have here, Supreme Court case 497 U.S. 835, that talks about the fact that you can present the court with evidence that your client is afraid of the perpetrator. And as long as there's some competent evidence of that, most courts will allow things like video depositions, two-way CCTVs and that sort of thing. And 18 U.S.C. 3509 codifies that for federal child victims. So I would encourage you to talk with your client about testimonial accommodations, to think about that issue early, and if you're going to want testimonial accommodations, try to get consent of the prosecutor in advance, and if you can't, file a motion early, well in advance of trial, so that you have a testimonial accommodation. That issue is put to bed, because that's a very important issue for a child victim. One thing, going back to the first question about where do we stand, when you're asserting one of these rights, the thing that you want, your goal should be that I want to stand with the prosecutor, because you want to have the prosecutor on your side if possible. If the prosecutor will not take a positive position on your client's position, so if they won't support your motion, if the prosecutor won't make the motion, then at least try to get them to be neutral. If the prosecutor is supporting you in your position, then you could stand at trial table with the prosecutor. If the prosecutor is taking no position or is taking an adverse position, then ask in advance to have a separate desk put in the courtroom for where you're going to stand and address the court, because it's important that you want to physically show that there is a divide between me and the prosecutor. It puts pressure oftentimes on the prosecutor, but you want to deal with that issue in advance, because you don't want to be in a situation where you don't know where you're going to be standing in the courtroom. So that's, it seems like a little issue, but it actually can be a very important issue, and you want to be strategic in the way you deal with it. Attempts to exclude the child victims and you need to be prepared, especially, the first time you go to court, to tell the judge what your client's right is in terms of your client's right to be there. And with this, I'm talking about, most victims are exempt from the sequestration rule. So that, that's a common tactic of defense attorneys, to call the rule on witnesses and to exclude anyone who's testifying, including the victim. In federal law in most states, there are exceptions to the sequestration rule for child victims. And so you want to be aware of what the law is and to be armed with that. You also want to be armed with any authority about your right to speak on your client's behalf, because defense attorneys will oftentimes object to you being able to say anything to the court. And the fact that you're even allowed to enter your appearance and be heard at all, they will object to, and they will always raise standing issues. Do you have the standing to present this issue, or does this have to be presented by the prosecutor? And so you need to be prepared to address those. The final aspect here is the intrusive discovery. This is becoming more and more common, where defense attorneys will seek, every record in a child's schooling. They'll seek Facebook, Twitter, everything, every kind of social media that you can imagine. You want to be prepared to resist these types of, third-party subpoenas, and you want to be on top of what the prosecutor is turning over, because prosecutors oftentimes won't tell you, and you need to figure out very quickly what it is that the prosecutor has and what they intend to turn over. And you could file a motion with the court seeking at least a protective order as to what's done with the information, whether it's shared with the perpetrator, a defendant, or preventing the prosecutor or a third party from turning over information that pertains to your child victim. And I would encourage you to go on the NCVLI website, which I gave you in the earlier slide, and there are pleading banks there about motions to quash subpoenas, form motions that rely upon the Roe v. Wade privacy rights, but also rely upon state and federal statutory protections for child victims. This will allow you to really prevent, the kind of re-victimization and re-traumatization that defense attorneys are oftentimes trying to inflict upon your child. The last, thing I really want to address here is the victim impact. And one thing to keep in mind is there's a real divide between the procedural rights that a child victim has, or any victim has, during the innocence phase of a trial and the post-trial rights. When you're talking about the innocence phase, you're talking about, constitutional rights of defendants, most times really rolling over the victim's rights. Post-conviction is another matter. In the post-conviction, you're talking about the rights of a convicted person against the rights of a child victim, and oftentimes you will score major victories in asserting rights post-trial. the thing that I like to say about post-trial rights is there are two real goals to victims' rights. The first one is to protect your child from re-victimization. The second one is to give a face and a voice to the victim. The state is a cold, hard entity, in the military, wherever. And your job, the thing that you can do to really influence the process, as long as your client's on board with it, is to bring your client to life for the court. And the best way to do this is through victim impact. Victim impact is, in my practice and experience, critically important. It can be absolutely a difference maker, for both in terms of your child, victim, and their feeling about the process and how it went, and in terms of the players in the system and how they feel. So I would encourage you to meet with your client, to gauge your client's interest in doing victim impact. One thing to keep in mind is courts are very, very liberal for the most part on allowing accommodations. They allow the child to sit on the lap of a mother or a supportive person. They allow all sorts of creative accommodations at sentencing because the same rules don't apply as the guilt and innocent phase. So one thing that I find important is if your child victim is not going to speak directly to the court, use video or pictures. The court really needs to understand that this is a person who has been impacted. And, the defendant will be all over that in terms of presenting themselves as a human and begging for mercy. Your job is, as a counterweight to that, to demonstrate to the court, here's the impact, and here's the person who's impacted, and here's how they were impacted. And then just a brief word on restitution and financial stuff. I find that, first of all, you should keep in mind that most victims have no hope of recovering any money from anywhere other than through restitution. Restitution is there for a reason. The law is expanding tremendously. There's been a lot of changes in the law. I encourage you all to go on some of the websites that I gave you and take a look. There's a Supreme Court case last term about restitution for child victims and child pornography cases. So the law is expanding to really require offenders to pay back victims for things like future counseling expenses, future lost wages even. And those are really encouraging developments in the law. An effectively presented restitution request in a criminal case can really add to the victim impact portion of the presentation. So you're demonstrating to the court the emotional impact and the financial impact, and that can have a dramatic impact on how the child feels about the whole system and the way it went, and how the court deals with the offender in terms of sentencing. So that's all we have time for. I gave my contact information. I would encourage anybody who needs forms or needs practical advice to reach out to me. I'm happy to help in any way that I can.
Great. Thank you so much, Steve. That was really helpful. And, as far as, especially on behalf of the ABA, we're always so grateful to have attorneys like you who are willing to share your expertise with folks who are practicing in this area as well. So I appreciate you and all of the speakers, and I want to thank the panelists so far. So now we're going to open it up to questions. We do have a few that have come in. I'm going to encourage you to, if you have any questions and you want to call them in, now's the opportunity to do that as well. So please feel free to call in a question as well. So I'm going to toss this out to the three speakers, and they can decide how best to answer it. Maybe a couple of you might want to chime in. So the first question is do I as an attorney ever need to know the full story from the child themselves, or can the attorney simply lean on the forensic or rely on the forensic interview? The attorney is worried about re-traumatizing the child, and that could potentially be creating memories by asking the wrong questions. So do any of the speakers have any thoughts that they would like to share on that?
Well, this is Julie, and I have several thoughts. The first thing that we want to make sure to understand is that the research is very, very staunch in saying that once a child reaches 10 to 12 years old, the child is almost equal to adults in terms of suggestibility. So if you're talking about an older child victim, you have a lot less concern over the suggestibility elements in your question strategy. But if you're using these more open-ended questions, practicing, using the narrative event practice to establish a narrative conversation, then you're also going to minimize suggestibility. So I wouldn't worry so much about this idea of creating memories, but the idea of re-traumatizing the child, the thing to think about would be that for many of us, the more we tell something, and some of the clinical research suggests this as well, the more we tell it, the better off we are in the telling of it and not keeping it closeted. So there's that issue. I wouldn't worry as much about that. But the key to your question is really what your role is. So if you've got a forensic interview that indicates to you the details of an event that is abusive, and you're trying to assist the victim in figuring out some of these things that Steve talked about, what do they want? Do they want restitution? Do they want some of these other things? It might not be essential for you to know all the details of that abuse in order for you to do your job in representing the child. But if you need that information, it's not accessible to you either in the forensic interview or you need more information to assist the child and represent the child, I would say doing that in a way that's really much more open-ended is the best way to go about it. But I do want to toss this to Dr. Solchini to talk about it from that clinical perspective as well.
Hi, this is Joanne. I echo what Julie said. I think when children experience traumatic events, actually talking about them can make them smaller and smaller. So, I'm sorry. Oh, okay. So anyway, it can make them smaller and smaller. Part of it is while you're talking about it, you can also do things like, sounds like you handled that really well, or those kinds of things. And to be honest, if kids don't want to talk about it, they'll tell you, I don't want to talk about it again. I've already talked about it before. Again, if it's something you really need to know, you can say, I know this is really hard, but this is something that we do need to talk about. But in general, it should, over time, the natural course of trauma that's being healed is that they're able to tell the story. So it's just what happened. The emotional piece of it starts to fade away or to not take on as much emotional intensity, if that makes any sense. But usually talking about something that has already happened, that you're in moving forward and healing, it's not re-traumatizing. If you were asking things and then getting big emotional responses, that can certainly cause them to be thinking about things for a couple of days. But usually, it's what we do with kids, and they tend to do really well with it.
Stephen, do you have anything to add from the attorney perspective on this?
No, other than I think that, I agree with everything that Julie said. The only thing I would add is that I think it's important to try to get a handle on what kinds of recorded statements are out there, and try to understand exactly what the universe of statements are, so that you understand whether or not you need to move to try to protect some of those statements to keep them away from defense attorneys and other things. I would also, say that, you have, as a lawyer, as a victim's lawyer, you have an opportunity that the state doesn't necessarily have to kind of, try to gauge what kind of a witness, the child's going to make. Prosecutors oftentimes don't either have the skills or the interest in adequately preparing child victims for testimony. So that may fall on you, and so you may be required to do some of that, some of prepping your child witness, and in the process of doing that, you will have to get into some of these issues. It really depends on the circumstances and the degree to which the prosecutor has thought these things through and brought in the resources. But other than that, I would just echo what Julie and Joanne said.
Great, thanks. I would like to ask the operator, could you please tell folks who may just be on the phone how to go about calling in their questions?
Certainly, thank you. Ladies and gentlemen, if you'd like to register to ask a question, please press the star key followed by the number 1 on your telephone keypad. If your question has been answered and you would like to withdraw your registration, please press star 1 on your telephone keypad again. If you're using a speakerphone, please lift your handset before entering your request. And so far, there are no phone questions, so I'll turn it back to you, Anne-Marie.
Thank you so much. I appreciate it, Bonnie. Okay, so I have a few more questions for our speakers. For Stephen, what do you believe the VLC should do if the child says they don't want to or are afraid of testifying at a military justice proceeding. I think it kind of piggybacks on what we were just talking about, but do you have any additional thoughts to share with the folks on the webinar today?
No, other than I would really, offer the child the testimonial accommodations and, look very carefully at the authority that I've given folks, because there are specific evidentiary requirements for that. But I think that can really make a difference, not having to see the perp, not having to be in a big open courtroom. I mean, those kinds of, accommodations can really help. Sitting sitting on the lap of a supportive person, courts are usually pretty liberal in allowing those kind of accommodations, and they can really make the world a difference. And the other thing to keep in mind is if the child could have very good reasons, and there could be a lot of reasons why the child shouldn't testify. So working with the therapist and the support network, the lawyer can, that can be a really good part of your job, is to figure out whether it's a good idea for, maybe overall it's not in everyone's best interest, and there are other types of evidence that might be preferable. And the child's reluctance to testify could be telling in that regard. So, I think it's just it's a case-by-case kind of analysis that I would recommend that others call in lots of folks like Julie and Joanne and other, supportive professionals to help with that.
Terrific. Thanks so much. This is a question for Julie. For folks who are not as comfortable with the narrative format that you discussed with us earlier, what would you suggest? What's the best way for them to become comfortable with that, and how would you suggest that they, folks that are serving as Special Victims Counsel, become comfortable with that?
I think that's a fabulous question, actually, and one that we all struggle with. The key is that it really behooves us as adults to get comfortable with it, because if we're asking children closed-ended questions, we're not getting the information we need to truly represent them and figure out what information they have for us to assist in this process. So tell me all about questions can be very, very helpful. Tell me all about your day. And it's funny because it can be semantics. I find that growing up in the Midwest in the States, and many people that I teach from this part of the world will say things like, tell me a little bit about yourself. And those things really minimize the amount of information we get. So we want to get into the pattern of saying, tell me all about, or tell me everything. Parroting back, Anne Graffin Walker in her work uses a concept called framing first and asking second. So parroting back something that the child said and doing a big narrative. I heard you say that you were worried. Tell me all about being worried. Or you had mentioned that you had been hurt. Tell me all about being hurt. So instead of us going to that investigative mindset of, you said you were hurt, who hurt you, or where did they hurt you, or what did they hurt you with, really trying to push ourselves to come back with those tell me all about, tell me everything, and doing it in our daily lives, doing it at the kitchen table, doing it with our friends, to try to get ourselves in that pattern of speech, which is really highly unusual. But it takes work, but it definitely makes a difference.